I am very happy to welcome everybody to tonight's panel, where we will be talking about gender entries, non-binary gender entries, what they are, why we need them, and why strategic litigation and lawsuits are so important all over Europe to move forward in this regard. And just a quick starter on some terminology that might be important for the discussion later on. And I hope that in the audience we have some people who are not yet aware of all of the aspects that we'll talk about tonight. We will be distinguishing between gender and sex. Gender refers to the gender identity of a person, what they themselves state as their gender. And sex refers to sex characteristics, as in physical sex characteristics. And also a term that might be coming up tonight is intersex people. Intersex people are, or intersex is an umbrella term that refers to a physical spectrum of variations of sex characteristics, so that naturally occur within the human species and that do not fit the typical definitions of what's male or female. And non-binary gender entries that we'll be talking about tonight are important for intersex people, as many intersex people, around a quarter, recent studies have shown, identify as non-binary, as not only male or female, but they're also very important for people beyond that with a non-binary gender identity. So that maybe just like a quick overstart, our ground for the discussion that we'll be having. And now I'm incredibly enthusiastic to introduce tonight's panel. I was so happy and lucky to put together this set of experts. For all of those that don't already know, I will introduce the people on the panel. And I will start with Arpi Avetisyan. Arpi is a human rights lawyer and works at ILGA, the International Lesbian, Gay, Bisexual, Trans and Intersex Association. And she's responsible for their litigation work and has as such coordinated numerous interventions at the European Court of Human Rights and done comparative research with regards to trans and inter rights. And I have the pleasure to introduce Lea Beckmann next, who is joining us on the same screen as Benjamin Morin-Puech. And Lea is a Paris-based lawyer who is working on health law and on compensation law, amongst others. And she specifically represents persons of special vulnerability and as such has litigated numerous cases of intersex rights cases at the national level in France, but also at the international level at the European Court of Human Rights. And she is the lawyer representing a client of a case that is currently pending at the European Court of Human Rights that we'll be talking about later. And she is sitting next to Benjamin Morin-Puech, who is a senior lecturer at the University Paris II Panthéon in Paris, and has a PhD in law and is currently on track to become a full professor of law at the university. And he specialized in privacy law, has numerous publications on the issues of gender, sex, and in particular on intersex rights, and has also accompanied many strategic lawsuits with interventions at the international level. And finally, I would like to introduce Alex Recher. They are a Swiss lawyer, a former member of the board of Transgender Europe, and a founder of the Transgender Network Switzerland, TGNS. And there they consult trans people on their rights, coordinate lawsuits in individual cases, but also strategic lawsuits that have an impact beyond the individual case. And now finally, I would like to introduce myself. I'm a human rights lawyer from Berlin, and I work for GFF, where we coordinate strategic law cases with regards to human rights. And I'm responsible for our anti-discrimination work, and as such, responsible for a case also that regards gender entries and the legal situation in Germany that is currently pending before the Constitutional Court. So I actually think that we have managed on this panel to bring together quite an inner circle, a set of people that are working on lawsuits with regards to gender markers across Europe. And a quick overview of the discussion that I would like to have tonight. And we have a lot of things to cover. I hope we manage through. But I would first like to have a little introduction on the subject. what are gender entries, where do they appear, why do we need them, and then dive into strategic litigation, and in particular cover the French case that Mila is representing, and where ILGA and also Benjamin Morin-Puech have offered intervention at the European level, and then go cover a set of 2 Swiss cases and 1 German case, with a bit of a focus on the Swiss case. And hopefully we will then have some time for discussions. So everyone who's listening, please write messages and questions in the chat. We'll be happy to pick those up whenever we can. So to start with a general question that I will direct to you, Benjamin. Benjamin, if we look at the history, have we always had gender entries? And do you think we will always need them?
Well, what's interesting when you look back at history is that in the past there were no proper civil statutes. I mean, a document published by the state and which will be used all your life long to prove who you were. To prove this, the main tool that was used were clothes. So clothes would say much more who you were than any paper. People in the Middle Ages were quite pragmatic. You know, they didn't trust so much papers, and papers also was invented quite lately, but they trust what they see in their everyday life. So it's interesting to see that in the past, when you wanted to live in a different gender than the one you would be you had been living, it was possible under certain circumstances to change your clothes, and by moving from a city to another one, you could be recognized in some circumstances. But all of this changed when started the rise of a bureaucratic state that used paper and want to put people in boxes. And from this time, it became more and more complicated for people to have a more fluid conception of gender. And this is when main issues started for trans people. And it's a bit a paradox, because on the same time you had the rise of human rights, and we will see today how they can lead us to get rid of gender. But at the same time that human rights were rising, you had the rise of a bureaucratic state that want to put people into boxes. And now we are in this time of strong tension between those two movements, and we don't know yet who will win, but for myself, I believe that human rights will win this battle, and that we will finally have more flexibility and maybe get rid of gender marker in the future. And it will show maybe a little a way back to Middle Ages.
And just one follow-up question. Why is it, Benjamin, that states register gender? What is the arguments that are made to register this piece of information on people?
Well, the idea is that humans are not equal. I mean, gender will start to be registered in the time where it was important to distinguish male and female. And the idea behind this is that you had different statutes. So in the Middle Ages, in Rome, in ancient Greece, the principle of equality was not recognized yet. You have to be in boxes because you had different rights. But now that we have the Universal Declaration of Human Rights, we don't need to put people in boxes anymore. We got rid of some boxes regarding races, religion in some country. I think we could do the same regarding sex or gender.
So we're not going to be very diverse, I think, with regards to opinions on this panel. We all agree, but I'll ask you nonetheless, Alex. Do you think we need gender registration? And then follow-up question, seeing that we have gender registration in, as far as I know, all countries worldwide, if we have gender registration, what do you think a good approach to gender registration would be?
I think there are two answers to this question. One is as a human, and there I would say, no, we don't need any gender marker. But as a lawyer, as Benjamin said already, we have different rights in some countries, depending on your legal gender. So for example, in Switzerland, at the moment, it's only allowed to marry when one is registered as female and the other one is registered as male. Or when it comes to the duty to do military services. In Switzerland, you have a duty when you're registered as male, and it's voluntary when you're registered as female. So on that background, we still need these boxes But it's human-made that we need these boxes. It's not nature-given that we need them. And the topic we talk about today is non-binary registration. So that shows already that this limitation to 2 boxes the law makes, or the registration the state makes, is too narrow. So I would say currently we have laws in place that force us to register people with a gender, but we can also say we change the laws. So what is the idea behind straight marriage, or what is the idea behind who has to serve in the military? And then we will probably, when we go into these discussions, we will see that it's not about how you're registered. It's something else. And I think these are the discussions we have to have in our societies.
And if you were to imagine a good way that gender registration would work, what do you think are key aspects that should be respected with regards how people are registered with regards to their gender?
As long as there is gender registration, I'd say the principle must be self-determination, so that you're registered as who you really are, as what you can identify with. Because it's quite violent if you're registered as something you are not. And that is the case we have now in many countries for non-binary people, that they are forced to be registered as male, as female, and that shows on all their documents. So they always have to present themselves, at least by documents, as something they are not. And therefore, I think, like, as long as we have registration of gender marker, it has to be based on self-determination. There have to be more than 2 options. And if you want to change it, your gender marker, it has to be a procedure which is quick, so that you don't have to wait for long because it's urgent, which is transparent. So it's a clear procedure which is defined, which is the same for everyone. You can read in a law what to expect, and which is accessible for everyone. No matter what your background is, what your age is, what your health status is, what your sex characteristics are, what your financial situation is, that it's just like open to anyone who has the need to get a gender marker which is in line with your gender identity.
That leads me over to Arpi. I think Arpi, you with ILGA and together with OII Europe, which is one of the most important intersex organizations at the European level, you have worked on a map of what the situation right now is regarding non-binary gender markers in Europe. Do you think you could give us a bit of an overview what the situation is right now?
Yes, and I'm sorry, I'm smiling. My daughter just approached and say hello. Okay, I'm really sorry. She just wanted to join, I guess, us as well. So to answer your question, we as ILGA Europe, we have our rainbow map, which is a map that we produce and update every year. And legal gender recognition, and including, you know, the information on non-binary gender is one aspect of it. But I would also like to point out to trans legal map that is produced by TGU, Transgender Europe, similarly updated and produced every year. And it's done based on some indicators. Unfortunately, if we're talking about non-binary markers, that there are only 2 in Europe, 2 countries that allow for such registration, and it's Malta and Iceland. Alex mentioned about self-determination, which is a very important aspect of legal gender recognition. So I just wanted to address that as well. And in Europe, there are only 8 countries that provide legal gender recognition based on self-determination. And then, yeah, I guess I'll stop here and to allow time for further discussion.
I have a little question back. So you said only Iceland has true non-binary gender recognition. In Germany, we do have the possibility to have a blank for gender entry, and also the possibility to put diverse. You did not count this because it did not fulfill some of your criteria, or?
For non-binary in general, without any specific, because I understand it's for intersex people, right? And if we are looking into that there have been good precedents by the Constitutional Court in Belgium, in Austria. So I just wanted to kind of share about more relaxed, not grouping people, not tying to any of the identities or sex characteristics in that sense. But otherwise, there are developments and we see movement across Europe, which is a very good sign and a welcome sign.
Yeah, I think that was a really good and important point to make, that it's important to not have that links between intersexuality or sex characteristics and gender identity, but to have a true link to gender identity, which so far is quite rare in the situation that we have. So after this brief introduction to what it is that we envision, kind of, I would like to jump to the subject of strategic litigation. So for those that do not know the concept of strategic litigation, it means using legal interventions, very often lawsuits, to not only have an impact in the individual case, but beyond the individual case. And in civil law countries, this can be done either by setting precedents. If a high court decides on interpreting the law in a favorable way, that can have an importance beyond the individual case. But also very often constitutional courts play a particular role, or cassation courts, or courts also at the international level, where that refer to a different frame of law, either the constitution, human rights law, and that can in effect cassate the ordinary law as it is, and thus move for a change beyond the individual case. And we all, in some regards, are working on strategic cases, and I think to show how this works and what is happening right now, the French case is a very good example, because the French case starts out in a country, if I understand correctly, that does not have any possibilities for non-binary gender entries, and is trying to make its way up through the instances to change this. And Mila, I'm so happy to have you tonight as the lawyer who has been litigating this case. I wanted to ask you, could you tell us about the background of the case? What is the claimant? What is the situation of the claimant? And what are you trying to pursue with this case? What did it start out before the national instances?
Thank you, Lea. Thank you to all of you. So first, strategic litigation for us is also to choose the case and the person on the one hand, and the subject on the other hand. So this case, it was our first case, and we took several years or months, maybe 1 or 2 years to prepare this case. It's not like a case in an ampli law. You have the clients and you go before the court in some weeks. We had to prepare this several months ago, because we had to research, to make researches over the French law and on history. Because in France, the jurisdictions and the judges want, and they like when you explain them the origin of your request. And they like history in France, so we had to explain them why and what were the case law before the French Revolution, and means to convince the judge. You have to put them in your case. So we spend a lot of time to prepare it with our client, and we chose this case because there were a non-binary client, and he had all these records, medical records, and and a lot of documents, a lot of letters, a lot of exchanges, written exchanges. So that it's perfect. You have proofs, and in a lot of intersex cases you don't have those proofs. So it was very important for us to have this case. So the problem in France is what is not said by the law. In principle, when the law doesn't say nothing, this is you have the freedom to do to do the action you want to do. But in France, they said us, even if in the law you don't have a prohibition rule, you can't do the inscription of the neutral case, of the neutral mention on your register. So in French law, you have a rule that says in the birth register, we have only to register the sex of the person, but nowhere the law says that you have to register a female or a male sex. So we decided that when the law does prohibit something, you are free to have this mention. The first judge say yes, yes, of course. Your client, you prove that your client is a non-binary person, and we have the proofs. This is fantastic in our case, that we have all the proofs you can imagine. We have medical proofs, and we have civil proofs, psychological proofs. We have all the proofs you want. But the Court of Appeal say that, oh no, this person, he is like a man. When you see it, he is like a man, and he has got married, and he has got a child, and so this is a man. What do you want to us, you know? And the Supreme French Court said, oh, you know, but the binary principle is a very important principle in French law, and it structures all the French society. So we can imagine a third gender. And they said this, they say this regarding the Article 8, but without making the proof of you know, when you invoke the Article 8, you have to do some verifications to know if this article is applies to the
Article 8 means. There might be non-lawyers listening to us. So just to briefly make sure that I understand correctly, you have a case of an intersex person with a non-binary gender identity who would like to have changed their gender entry to reflect their gender identity, and do you specifically say to what the term is that you would like to have registered, or?
Neutral. It was neutral.
It was no. First, the first request was neutral, and the second request was intersex. And in French law, when the judge says, "Okay, I admit your request," he doesn't care about your second request. So he said, "Okay, for neutral gender." And after that, you had an appeal from the public officer, and that's why we go before the court of appeal.
Okay, and so then you had the first instance said it was a success. You got neutral accepted. It went to appeal. Appeals court rejected, and then it went to the Court of Cassation. And what happened at the Court of Cassation? I think that's where you invoked Article 8. I think you will have to maybe elaborate in a bit non-legal terms about why you failed at the Cassation Court, and you think.
So in principle, Myla is giving me the floor. When Article 8 is used, it means that you have a right to privacy. So Myla's client was saying, by forcing me to keep a male marker, you're breaching my privacy because I'm not a man, I'm a neutral person. And by forcing me to go in a box which doesn't correspond to me, this is a breach of my privacy. And so the court accepted to enter in the discussion, but they didn't enter it in good faith. So there's various criteria. It's possible in law to refuse someone a request when it regards its privacy under 3 conditions. So first, it has to be written in the law under what condition they can be a breach of privacy. So if there is a specific law that states under this and this condition it is possible to breach your privacy, then the first criteria will be met. As Myla has explained, it is written nowhere in the law that it is not possible to be neutral. But the court says it is written in the French law, but you cannot find any French law where it's written. So it's just a mere invention of the court. It's a lie. So the second condition is that you need to have a legitimate aim. So when you want to breach someone's privacy, you need a legitimate aim. And there is a limited list of the legitimate aim that are allowed under Article 8. The French Cour de Cassation, they created a new legitimate aim that is not in the list, okay? And then thirdly, there is what we call a proportionality test. So you have to see what are the interests of the society on one side and the interest of the individual on the one side. And you have to go concretely. You cannot make abstract judgment of proportionality. At the court, they made an abstract judgment. So the final decision of the Cour de Cassation is really is not a legal decision by its reasoning. And it's quite non-surprising when you listen to what one judges has said after delivering their decision. The judges says, well, we had to find something to reject the case. So clearly they didn't want to admit this case, and they'd find some kind of legal arguments which were not really legal arguments to reject it. But this is not a good reasoning.
I think that kind of shows the difficulties that we all have in court sometimes with our cases when we are in front of judges that might just be of also a different background and thinking, and that cannot grasp the realities that are brought before them, and thus don't rule in our favor. Arpi, I would like to ask a question to you, because at the next stage after this case failed at the Cour de Cassation in France, Mila brought it to the European Court of Human Rights, and that is the moment where both ILGA and Benjamin made intervention at the European Court of Human Rights, which means third-party intervention, a statement where you as an NGO working at the European level present your arguments why you think that the case should be successful before the European Court of Human Rights. Could you briefly already say why you made these 2 interventions, why you think they're important, and then also the key arguments that you made in your intervention?
Yes, thank you, Lea. So we had been following the case when it was at the domestic level, because it was one of the rare cases taking place, and of course it would have an impact not only on the applicant, but have a much broader impact on other people in similar situation, and not only in France, but across Europe and internationally. So just to say from the outset, we were following the case and developments taking place in France, and when it was submitted to the European Court and communicated, it was natural to consider an intervention, because this is a novelty area, and one of the aspects of third-party interventions is to support the court, in this case the European Court of Human Rights, on delivering the judgments with having a broader understanding of the issues. And it's true, in this case we intervened together with OIA Europe, and Benjamin organized a separate intervention, one of the reasons is that interventions are very structured. So there is a limit as to how many pages it can be. It's usually about 10 pages. And by bringing different perspectives, addressing different perspectives, it was very useful to have 2 separate interventions that could complement each other, provide a bigger picture to the European Court. And of course, we presented more European and international perspective, and Benjamin could bring domestic, situation and views on the French system that we would not be in the position to do. So that's about third-party interventions. And in terms of arguments, because it was, I mean, it's not strictly the first intersex case. There was another one brought by Ukrainian intersex person a few years ago, about 4 years ago. It wasn't about a third gender or a non-binary. It was just about the procedure, legal gender recognition process that the applicant found to be struggling with. And I think it's worth also mentioning about this because the procedure itself can be very burdensome for intersex people, but also non-binary people. In that particular case in Ukraine, there was some kind of not ideal procedure, but it was available for trans people. And when this person wanted to get her documents changed, was told that we don't know what to do with intersex people, you know, when you want to change your documents. So why won't you get a medical certificate that you are trans? In that case, we know what to do. But this was also very wrong because the person wanted to be recognized as intersex and wanted the procedure to be available for intersex people. So we had intervened in that case, which unfortunately was struck out because the domestic remedies were not exhausted, and the applicant has restarted the case with a view of, again, if need be, to go to the European Court. But after that, this was a very important case because, again, it would shed light on the rights of intersex people. It was the first one on non-binary gender marker. So we wanted to bring the knowledge to the court on who are intersex people, you know, to bring more information about sex characteristic, the spectrum of genders, that it's not binary, male and female. We wanted to stress the importance of self-determination, which we included in our intervention. Another aspect that we highlighted was the violence and discrimination faced by intersex people when they don't have their actual, the documents that they feel comfortable with. And I'm kind of trying to use less legal language in case, you know, the audience, we have no lawyers in the audience. And lastly, we provided international and comparative examples and trends, because in Europe we do see a trend. It's not very fast, it's incremental, but we see a trend. But also, you know, we hear more from other systems. Inter-American system has been vocal, both about self-determination as an important aspect for legal gender recognition, but also about non-binary registrations and intersex people. So we tried to cover all this and bring this information to the European Court to help in consideration of the case.
Maybe a last question to about the French case and to you, Arpi. Do you think that the European, I mean, having kind of failed before the French courts, do you think the European Court of Human Rights is a good legal avenue for, I would say, the queer community in general, but particularly here with regards to non-binary gender entries? Do you think it's a good forum? And are you optimistic of winning? Or is it just the last thing to try when everything has failed before the instance courts or the national courts?
So from the beginning, we knew that we will bring the case before the court because it was a first case. So we knew that even if we won in the first instance, there would be an appeal from the prosecutor in France because it was the first case. So it's not you know, the end of a proceeding. It's, you know, it's like the beginning of a larger reform in France, I think.
And maybe Arpi, particularly with regards to the European Court, do you think there is a good chance that this will actually win?
I would like to answer that question with a big hope that it will be. But of course, it's difficult to say. It depends also, even if I really hope to, it might be decided also not in general terms, but might
I think we lost Arpi here.
be very narrow and applicable. Oh, am I back?
Sorry, yeah, your internet connection was kind of cutting.
Oh, I'm sorry. So I don't know where you stopped hearing me, but I was saying that there can be different scenarios and on how the court would adjudicate. So it can be very broad to say, yes, there must be neutral, or, you know, whatever they would call the gender available, a third gender available. There might decide that it's, in a way, the wording might be that it would be applicable to the applicant, but not require wider structural changes, because that sometimes happens as well in court judgments. And of course, there might be a decision that is negative to say that there is no margin of appreciation, and which means that, you know, the European system is not ready. So I'm just bringing different scenarios. I'm hoping it will be the first case that the court will recognize the need and will have a positive judgment. But even if it's a negative decision, I would say it's building on. We need, if not, yeah, sometimes the big bang is not possible, but incremental change is possible. And one of the reasons, as I said, for third-party interventions was the raising awareness on the issue. So I truly hope that it will be a positive decision that we can build on.
Yeah, I think that's already a very important aspect of trying to work with strategic litigation. Even if you lose a case, you know, you have to lose 5 cases in order to be able to lose that 6th, to win that 6th case and to finally come about some change. So I think that comes with the territory, the possibility to lose, but that doesn't mean that you're losing, that we're losing in the long run. And now I would try and take it from the French case over to the Swiss and German cases. And just briefly, I think it's good we talk about it in this order, because in Germany and also in Switzerland, we kind of have these follow-up cases already, because this they both are built on the German law. And in Germany, we did have a successful case before the Constitutional Court a few years back, which was a similar case, a kind of perfect first step in, a non-binary intersex person that, and the courts in 2017 in Germany ruled, number one, gender identity is what we're marking in the registry, which was a very important point to make. And then secondly, offered the legislator to change the law, either to completely strike gender registration or offer positive also gender entries for non-binaries. So in Germany now we do on paper have the possibilities for diverse, an empty space for gender entry, and then male and female, so 4 options. But we have different avenues to get there, and not a perfect legal scenario. But nonetheless, we have Swiss nationals in Germany who have managed to get these non-binary gender entries. And maybe Alex, you can tell us a little bit about what these, how you in Switzerland, what your legal situation is, and why you are using, or you know, the German avenue, maybe also to change something about the legal situation in Switzerland.
Yes, the legal situation in Switzerland is probably similar to the one Mila described for France. So our law doesn't say that we have only entries for male and female. It only says that you have to register every person's gender, but it's not limited on paper to male and female, but in practice, it is limited to male and female. And it's also that the register, like the computer system is built in a way that you can only enter male or female. There is a option of undefined, but the scope of application of this undefined is so narrow that it's very rare that it's even that it can be used. So more or less, we can say we also have a very binary system within Switzerland. That means that if me as a Swiss person, for example, living in Switzerland, having no connection to another country, I would probably have no chance to ask for a non-binary gender entry or to have no gender marker anymore. But we also have a international private law, and that's where Germany comes into the play. So there is now 2 Swiss nationals who are living in Germany. They both identify as not binary, not within the binary. And as they are domiciled in Germany, they had the possibility to make use of the German law. One of them has now the gender marker of diverse, and the other one has no gender marker anymore in Germany. And the Swiss private law says, or sets the rules for recognition of decisions abroad. There is a general rule on the recognition of register changes such as the gender marker. And then there are specific rules, for example, for a change of first name. For our cases, what is interesting is this general rule on the recognition of register changes abroad. There are some requirements which are not very relevant in our cases. It's more or less that it was okay to do the changes in Germany, what is obviously given because they're both living in Germany. And then the key question is whether the requirement of a breach of public order is fulfilled or not. So this means that Switzerland recognizes a gender marker from abroad in the registry. So this means that they would also change the gender marker in Switzerland to the same as in Germany, if it's not in breach of the public order. And that means that it's not against like the fundamental values of Switzerland nowadays. Not sometimes in the past, but really nowadays. And this is now the discussion. And what we argue is to say, like, within the Swiss society, we see a lot of changes currently of sort of social recognition of non-binary identities. So, for example, we have cities that use a non-binary language, explicitly non-binary language, because our official languages, German, French, and Italian, are very gendered. They're not as easy as English when it comes to that. So you can really make visible non-binary identities in the language. And we have cities doing that in their official communication. We have universities allowing students to write explicitly in a non-binary way. We have big commercials using non-binary language. We have more and more visibility. And then it's hard to say that in such time and place that it's not accepted or that it's against fundamental values of Switzerland to accept non-binary identities. So this is what is legally speaking, or in the national law, what is the discussion we're having. Obviously, we also argue based on international or European human rights. So the Article 8 that has already been mentioned before, Article 8 of the European Convention on Human Rights, which says that you have a right to respect for private life. And the court in Strasbourg, so the European Court of Human Rights, has said in the past that trans people with a binary identity have a right to respect of private life, in the sense that they have a right to have their gender marker changed. So far, the court has always been within the binary, and what is challenged now by the French case, and maybe later by a German or a Swiss case, is the question whether its gender identity as a part of right to private life is also applicable to non-binary gender identities, or whether it's limited to binary identities. And from a legal perspective, I would say such a narrow interpretation, such a limitation to gender identity to only non-binary people makes no sense. Because when you talk about non-binary identities, we talk about the marginalized and discriminated minority. And from a human rights perspective, that's the one you need to protect, not the privileged majority. So where are we now with our Swiss cases? I have these two clients. They did their changes of the gender marker in Germany under German law. And they approached us about 2 years ago asking if it's possible to have that diverse or no gender marker anymore also in the Swiss registers, because that's their country of origin. And I said, well, from a legal perspective, I think there is a way to do it. It's new for Switzerland. We don't know how the courts would react. And both cases have got a negative decision from the first instance, which is the administration of their region. And that's where we are with the one case, the one that has a diverse entry in Germany. And the other one, we were at that stage of the first negative decision some months ago. Then we appealed in a strategic litigation case to the regional court. And there we got a decision much faster than we ever thought. And we won like just fully. Like every argument we brought, they said, yes, you're right. It was a very positive surprise. So we were happy. The non-binary community in Switzerland was very happy. And then the Federal Office of Justice appealed against this decision with the federal court. And that's where it's currently pending. So that's the last national instance. And we will see what the outcome will be.
I think that shows very well then also how cases build on one another, and how no matter how the final result maybe at the High Court is, you've had that win at a certain court, and I think that that door opens up slowly. And I would like to briefly also tell a little bit the story about the German case that is currently pending at the Constitutional Court, because it is also a follow-up case to the case that had been won at the Constitutional Court here a few years ago. And right now in Germany, we deal with a situation of where the legislator implemented the then the Constitutional Court decision kind of in a narrow way. And now we have two avenues to change gender entries. And one is the law for transsexuals, designed in the 80s and declared unconstitutional in many aspects, but still in practice. And it means as a binary trans person, you have to go through a lengthy and costly court proceeding with 2 psychological assessments, very humiliating procedure that takes a long time. And there's the opportunity now kind of legally designed at intersex people, where a mere declaration before an administration is sufficient, but you have to show a medical certificate of variations of sexual, I don't know what the exact term is. It's kind of a reference to the medical diagnosis for intersex people, disorder for
sex development. Disorder of sex development, I suppose.
Sex development is the term that I was looking for, exactly. So it again tries to kind of link the gender entry, where the Constitutional Court made clear that it should be linked to gender. It's linking it to sex characteristics again. And we currently have accompanied a case to the Constitutional Court of a person that considers themselves to be agender, and also a very famous professor working on these issues in Germany, but a person that has never in their entire life felt they conform to this gender system, and went up with, we had some good, in this case, but also in other cases, we have had some favorable jurisprudence at the instance court. The highest court has rejected us, and now we have brought it to the Constitutional Court with the claim that we do need self-determination in the approach to gender entries. And so self-determination means not these psychological assessments requirements that we have. It means no medical assessment that we have as a requirement for intersex people right now. but it also means that it should be non-discriminatory. So not two different ways for people depending on their sex characteristics, but one way of accessing self-determined gender entries for everybody. So we have launched this case, we have launched the complaint last year, and we know that the case, the court will not decide upon the case this year. They publish a list of cases that they intend to decide upon, and we'll just have to wait and hope that next year we'll have a decision that kind of builds further on this. So we have a last 9 minutes, and I would kind of like to take a round with you to kind of discuss more on an abstract level now the advantages and challenges of strategic litigation when it comes to fighting for minority rights. Because we have talked about strategic litigation now, and I think it's kind of shown in what we said, that this is an important avenue, but maybe some of you can elaborate on why it is so difficult for minorities maybe to get important changes about in any other way, and why then strategic litigation, especially when it comes to minority rights, is so important. Arpi was nodding first, so maybe you could say something about this.
Yes, happily, I'll try. I hope my internet connection is okay and you can hear me. So yes, strategic litigation is I see it's being used more and more lately, and one of the reasons is I think that many governments or political forces are now not as favorable, and we see unfortunately in many countries also regressive laws being introduced, since when there is no political will, other avenues like advocacy, lobbying, they're not as efficient. And in many countries, in many cases, courts have shown to be more protective, understanding, and have really been more efficient way to do that. You also mentioned about pros and cons kind of strategic litigation. It can be a very good process to get a strong judgment, but one of the cons is that that someone, an applicant, a victim, has to go through that process. And of course, for us, we're looking for that one applicant who would be ready out there. Sorry,
you were cutting off a little bit, but just
in that. Yeah. So yeah, just to mention that important is to have a very strong case, as Mila and Benjamin already mentioned, and also Alex. But also to support the applicant to go through that, because once you identify a strong case that can have a wider impact, it's really important to support that person, because it's a lot of pressure on them, and that's one of the aspects. And then another aspect, just to mention this briefly, is implementation of those judgments, because sometimes we do get very good, beautiful judgments, either domestically or from the European Court, and then it takes years to then see the result, the real results. So that's another difficulty or shortcoming, probably. But there are also avenues to continue pushing for implementation, and we should not be discouraged. I'll give the opportunity for others to comment as well.
Maybe Mila, would you like to comment? Did you have any thoughts or concerns when choosing to do this strategic case with your client? Was there any ethical concerns at any point?
Yes, I really agree with Arpi. She said that there was a psychological difficulty for the clients. That's true. Our client, you know, he's alone, and I can't say what I want to say because I have the secret of lawyers. But it was very difficult, you know, to go before the first court and then to explain, oh, no, the first court, now you don't have this good decision. You have to go before another court and then before another court and then before a fourth court. You know, you can't understand. And it's not a pecuniary, you know, litigation. It's about you. And I have a thought about the other case we have before the court. It is about mutilation, genital mutilations, and the problem is the same, and it's maybe more difficult to have this psychological support. And I think there is the role also for the associations is to do some support to those people who go court, because you know, they are our friends now. You know, we know a lot of things about them, so we managed to be somewhere friends. But I don't think that they have actually the support of the associations of intersex people. And I think this is very important.
Yeah, I think those were some really good final remarks also, because we have been so far, and I mean, me personally also, talking about strategic litigation as this form of lawyerly game that we play to, you know, try a case here, try a case there, and finally we might win somewhere. But for the clients that we work with, this is it's not a game, it's their life. And it's very important issues for them. And I think that's a very important balance to strike, and to always put the client's needs first. And nonetheless, it's important maybe also to join up with activist clients and in some regard have this greater vision of what the great scope of things is about. We have about 3 minutes left. Alex, I'm sure you have some thoughts on this. Maybe would you want the final words?
It's a bit strange because I would also say, like, yes, what is really important is the well-being of the client. It's a human being in a marginalized position, but it doesn't mean that it's a weak person. It can also mean it can be a very strong activist, as, for example, your client Lea has already worked on the topic for a long time. So it's also a question of the individual. Who is it? What are their needs? But I think there's one point that has not been mentioned yet, really, and that's resources. That's something that cannot be underestimated. As a lawyer, you may choose to work for free as an association. If you hand it over to a barrister, to a lawyer, often money comes into play. Also, when you do it yourself as an organization and you're paid, money comes into play as well. And that's already something that's really important, to take that burden away from the clients. So to say, like, we take care of the money. That is not something you have to worry.
I think
and also I think, like, to be very clear and transparent from the beginning to respect the autonomy, for example, when it comes to media work or when it comes to talking about the cases, what is really, how do they feel about it? Do they want to go anonymous, or are they open about it? Do they want to talk about it, or do they prefer not to? It's a lot to be discussed and to be agreed on, always respecting their needs, their autonomy, and knowing that this can also change over the years.
I would like to thank this wonderful panel. We have reached our 1 hour. I could have continued talking with you. Any of these subjects we could have filled them with 1 hour, but we only had 1 hour to go through all of it. Thank you so very much for joining me tonight, and I hope you have a good rest of the evening.